So my legal tip today comes from a query I received from a follower. She said that she was married, they had kids together, they did the usual will, leaving everything to each other, but they are now separated with years, and she wanted to know, could she change her will to bypass the ex-husband and leave everything to her children? So my advice is yes, of course you can. However, what you need to be aware of is that you are still considered a spouse if you die, and therefore your spouse, if you die before him, is still entitled to claim his legal right share under section 111 of the Succession Act. I'm going to give you an example. I was at a course in Dublin years ago and I spoke to a colleague. He had been acting for a gentleman. This gentleman had gotten married. He and his wife never had kids. It was a relatively short-lived marriage. When they separated, changed his will to bypass now the ex-wife. He was leaving everything to his best friend and was naming him as executor. Anyway, about 2 weeks before their divorce hearing, he died of a heart attack. The proceedings obviously didn't go ahead. So when he died, he was still legally married to his ex-wife, and his ex-wife still had a right then to claim her legal right share under that section 111 of the Succession Act, regardless of the fact that they had the divorce proceedings issued. So she went to the executor, like she was entitled to, and said that she wanted to claim her legal right share. In the case where there's no children, that share is half. If there was children, the share would be 1/3. The executor, of course, in this case said absolutely no way, because he was also the beneficiary. So she had to go to court, and she went to court. It was settled, and she did get quite a large lump sum out of her ex-husband's estate. On top of that, I think she'd also gotten the house, which was in their joint names, because as you know, any joint property that is held jointly, that when one of them dies, it falls outside the will and goes to the survivor. So on top of the house, she also got a large lump sum of his cash assets. So it's something for you to be aware of. Make sure that if you are separated with a long while, go for your divorce. If you find the thought of a divorce daunting, go to the solicitor, go about doing a simple separation agreement where you can amicably agree what goes into it. And every separation agreement should have a little paragraph that says that you both renounce your rights to the legal right share under the section 111 of the Succession Act, which means then if they had done a simple separation agreement, that case up in Dublin, then she would not have been entitled to make the claim because of that little paragraph in the separation agreement that she would have signed. But in this case, that lady was quite entitled to claim her legal right share under the Succession Act. So if you know anybody that this might be helpful to, make sure to share the video and continue to follow us here at Dunn Solicitors and thejourney.ie. Thank you very much.